Malaysia's core drug legislation was written in 1952. In the early 1900s, international efforts like the Hague and Geneva Conventions focused on the trade of raw opium. By the 1960s, the market shifted to refined heroin and morphine, followed by a surge in synthetic amphetamine-type stimulants in the 1990s. Today, the fourth wave is defined by new psychoactive substances, or NPS, lab-created compounds that are engineered to bypass current chemical lists. Malaysia uses an interlocking framework of 3 distinct statutes to manage this complexity. The Poisons Act 1952 regulates legitimate medical and industrial access to restricted chemicals. Enforced by the Ministry of Health, this acts as the regulatory net for the legal supply chain. The Dangerous Drugs Act 1952 provides severe punitive measures against illicit trafficking. This is the punitive hammer used by the Police and Customs Department to enforce absolute prohibition. Finally, the Drug Dependent Treatment and Rehabilitation Act 1983 establishes a mandated medical pathway for users. Managed by the AADK, this serves as a clinical rehabilitative off-ramp. Mastering pharmaceutical regulation requires knowing exactly where these 3 distinct jurisdictions overlap and where they collide. The Poisons Act 1952 is the foundation for legal chemical control in Malaysia, enforced by the Poisons Board under the Ministry of Health. The Ministry of Health and the Poisons Board maintain legal control over the import, storage, and sale of chemical substances. Substances are classified into schedules. Group A poisons represent the highest level of restriction, encompassing potent medicines that carry significant risks if diverted. Handling these chemicals requires specific licensing. Type A is restricted to pharmacists. Type B permits non-medical uses. Type E is mandatory for import and export. A Type A license allows pharmacists to dispense Group A poisons, but only upon receiving a valid prescription. This differs from Type B licenses for non-medical industrial use, or Type E permits, which are required to import or export precursor chemicals. Historically, violations like selling restricted poisons without a prescription carried fines up to 5,000 ringgit. The 2022 amendment increased the maximum penalty to 100,000 ringgit and 5 years in prison to deter supply chain negligence. This update also granted enforcement officers the power to enter premises and access computerized data to track drug movements in real time. For practitioners, the most critical legal hook is Section 22B. Supplying a medication like cough syrup without a bona fide medical intention is a criminal offense. Section 22B connects clinical malpractice directly to criminal liability. While the Poisons Act regulates legal supply, criminal enforcement is governed by the Dangerous Drugs Act 1952, enforced by the Royal Malaysia Police and Customs. This pillar focuses on absolute prohibition. Sections 4 through 6 outlaw the importation, possession, and dealing of raw drugs like opium, coca leaves, and cannabis. Cultivation is also strictly banned. Under Section 6B, growing dangerous plants triggers life imprisonment and fines up to 500,000 ringgit. Indirect involvement carries weight as well. Section 13 makes it a specific offense to permit any premises to be used as a port for unlawful administration. The most powerful mechanism within the Dangerous Drugs Act is Section 37, the Presumption Clause. This clause establishes a rigid legal standard. Carrying specific weights automatically presumes the accused is a trafficker rather than a user. Possessing 15 grams of heroin or 200 grams of cannabis immediately triggers this clause. This inverts standard procedure. It shifts the burden of proof off the prosecution and forces the accused to prove they are not distributing the substance. While Section 39B once carried a mandatory death penalty, the Abolition of Mandatory Death Penalty Act 2023 changed the judicial landscape. The death penalty is now discretionary. Judges may alternatively sentence traffickers to life imprisonment and a minimum of 12 strokes of the whip. This weight-based logic is the primary tool used by the state to identify and prosecute high-level drug distributors. Applying the severe penalties of the Dangerous Drugs Act to every dependent user would fill prisons without addressing the medical reality of addiction.